So, what are these essential elements that are required to have a valid contract? And obviously, that's what we want to take a look at right now. Y'all, there are four main elements, but you see five listed here, and you'll see why here in a little bit. But I will tell you this would be worthy of memorizing. Okay, y'all, you need to know what the essential elements of a valid contract would be. Now, to be clear, I want to repeat something I said earlier. To have a valid contract, what does that mean? If the contract is valid, that just means it is enforceable in court. If it's invalid, then that means it's not enforceable in court. Doesn't mean it's not legal. Doesn't mean you can't still do it, assuming the parties agree to it. It's just not enforceable if the contract is not considered valid. So we want to make sure, certainly as a real estate agent, we want to make sure any contracts we are dealing with are all valid. We want to make sure they are enforceable. So what are these elements? Number one, there has to be an offer and an acceptance. I think that's kind of a no-brainer right up front. Hard to say you got a contract if there was never an offer or if the offer was never accepted. So that's number one. Got to have offer and an acceptance. Number two, there has to be some legal consideration. Now we need to talk about that a little bit, but so what is legal consideration? Consideration could be considered valuable, or in some cases it might be considered invaluable. But when we talk about valuable consideration, we're talking about the price paid. Consideration just means there's some benefit to be offered. Okay. So if I make an offer on a house and say I offer $300,000 in my offer, then my consideration is $300,000. That's the benefit that I'm offering to the seller in exchange for the property. So again, consideration is some kind of benefit in exchange for something else. That's what we're dealing with here. But as long as you're offering money, which is 99% probably of all real estate transactions, there's typically money being offered in exchange for the property. So that's your money is considered valuable consideration. But if for some reason there is no valuable consideration, in other words, there's no money to exchange hands, then there must be invaluable consideration. And the only legal substitute here as invaluable would be for love and affection. So basically, in the contract, you would have to write that, for love and affection, I would like this property or whatever. You see this from time to time, but it's not typical in a normal real estate transaction. You typically see it when one person is transferring land, maybe to a child, for example. Maybe I've got a daughter and I happen to have a house over here, so I'm just going to give her this house. Well, when I say give, you're not going to charge for it. Obviously, you could, then that would create the valuable consideration. But if you just wanted to give it to somebody, then you would have to use the invaluable consideration, which would be love and affection. So in the deed, that's the document that actually conveys ownership, it would actually state for love and affection. So either some valuable amount, valuable consideration has to be in the contract, or it must state for love and affection, again, which would be the invaluable. But one of those two must be agreed upon. But then we look at, in number 3, it says we have to have competent parties. Here's where it gets a little bit interesting, to say the least. Again, all parties on both sides must be competent. Well, what might render a party incompetent? Well, I think probably in most states, the legal age is considered to be 18 years of age. So anyone under the age of 18 is considered a minor. Minors are considered incompetent for legal purposes. Okay, so anyone entering into a contract that is not at least 18 years of age, then that would render the contract invalid, because you're not of legal age, or at least of the age of competency as defined by law. Obviously, all parties have to be sane. Insane persons, I guess, are considered incompetent. Now, hopefully, this is not something you ever have to deal with when you're doing real estate. But at the end of the day, I would think some professional would have to be the one to actually determine if someone was sane or not at the time they agreed to the contract. Hopefully that won't ever be an issue. But then obviously, we have to be competent. What are there ways to make an otherwise competent person incompetent? You bet. Maybe they've been drinking too much. They're drunk. Been doing drugs. Their mind's not thinking properly here. So, at that point, they're considered incompetent. Let me give you a scenario here, because this is important you really understand this. But say you've got two parties, one party wanting to sell, another party wanting to purchase. So they decide to, let's go to the local bar. Let's just have a drink and discuss the terms of the purchase and sale. So they do, they go and they start drinking, and let's just say, for argument's sake, they're both intoxicated. And I know you might say, well, to what degree? You can drink one or two beers and it still won't affect your thinking or competency. But let's just say, for argument's sake, they're wasted. Can't even drive home. Got to get an Uber or whatever. So they're both wasted. But while they're there, they sign a contract agreeing to purchase and sell this property. Well, do we have a valid contract? Well, let me rephrase. Let me back up a little bit. Under the scenario I just described to you, can this transaction go to closing? Can we close this deal based on that scenario? And I will tell you, most people say, no, you can't do it, because obviously they were incompetent at the time they signed the contract. And then, so that would render the contract invalid. So therefore you cannot close. Here's what I want to make sure you understand, not only for real world purposes, but also for test purposes potentially. There's no question the contract is invalid because the parties were not competent at the time they signed the contract. However, and what I was trying to get across to you at the beginning here, just because the contract is invalid, it does not mean it's illegal. Do not confuse that. Invalid does not mean the contract is illegal. Remember, what we say invalid means? It's just unenforceable. It's no longer enforceable in court. It does not say it's illegal. The reason that's important, if, say, the buyer wakes up the next morning, might have a headache or whatever, but at least they're thinking somewhat logically, and they think, I cannot believe I agreed to buy this property under these terms, and I'm not doing it. I'm not doing that. Well, if either party decides I'm not going to go through with it, then there's nothing the other party can do about it. Again, because it's not enforceable, right? However, if they both wake up the next day and decide, you know what, I like it, I want the property, and we're going to closing. Y'all, can they not still go to closing and close and transfer the property? Yes, they can. Again, there's nothing illegal about what they did. It's just not enforceable. So y'all be careful. Y'all, if you should get questions on the exam, y'all talking about stuff like this, or maybe give you a scenario similar to one I just gave you. Again, y'all, just because the contract may be invalid does not mean you can't do it. Doesn't mean it's not, or doesn't mean it's illegal. It just means it's not enforceable. You cannot force the other party to go forward with it. Okay. All right. So, that's the first three elements for the contract to be valid. But then number 4, there has to be legal purpose. Whatever you're agreeing to must be legal, right? If what you're agreeing to do is not legal, obviously it's not going to be enforceable in court. In fact, the laws pretty much or specifically states, any agreement that is not legal is considered void. It's as if there was never an agreement. You can't agree to do something that's illegal and then also expect it to be enforceable in court. Whatever you're agreeing to has to be legal. And then lastly, there has to be consent. All parties must consent. What does that mean? You cannot be under duress. You cannot try to force somebody into selling or buying real estate. If they're kind of pushed into it and they're under duress and they just sign it just so you'd leave them alone, that's not consent, that's duress. And that would render the contract invalid. Not only would it be invalid, but it would also be considered voidable. Because it is, any contract that's invalid means it's unenforceable. Also mean it's voidable. Meaning either one of the parties could just pull out of the contract again because it's no longer enforceable. So there has to be consent on both sides. And I will tell you, that happens more times than you might think. I've seen that a few times where I just felt like, typically when I see it, it's the seller being pushed, almost forced into selling property. And I'll tell you, and it's usually family. That's where I see it the most. Maybe you've got an elderly person and one of their children, or maybe all their children, are wanting mama to sell the house and move in with them, or move into assisted living or whatever, but mama doesn't want to. I want to stay in my home. I can take care of myself. But I've actually witnessed where children are all but just forcing parents into signing contract. Sale. You need to get out of here. That's not consent. Okay, so that's a no-no. So you got to be wary, be a little careful about when you see stuff like that going on. Obviously, contracts must be on legal form because, and I said this right at the beginning, any type of real estate contract, with the exception of one, but any type of real estate contract, I will tell you, typically is going to be subject to the statute of frauds. Now we're going to talk about more detail about what types of contracts are subject to the statute of frauds right after this little module. But the statute of frauds, remember, is a national federal law that just says any type of contract that is subject to the statute of frauds, it must be in writing. Again, just for the record, the only type of real estate contract that I'm aware of anyway that could be oral and still be enforceable is that oral lease. Remember, oral leases for 1 year or less would still be enforceable. But typically, if it's a contract that's not covered under the statute of frauds, more times than not, there are also state laws, and obviously this is going to vary from state to state. But most states will require other types of contracts, obviously dealing with real estate, but it may not be subject to the statute of frauds. Just for example, an agency agreement, an agency relationship. We talked about brokerage relationships, the laws of agencies and stuff, several chapters back. But those types of contracts, now that's not covered under the statute of frauds, as you'll see when we get to it. But however, I think probably most states, if not all states, have a state law requiring, that if you're going to enter into an agency relationship, where you're representing either buyer or seller, then that agreement, that relationship must be in writing. So you have state laws, and then obviously you got the federal law, the statute of frauds, that's going to require pretty much all real estate contracts to be in writing. Okay. And then when it comes to making changes, that this is inevitable. Pretty much, I'd say 99% of contracts you're gonna wind up making some changes to it throughout, from the time it's signed right on up until closing. But here's what you need to make sure you understand about this changes, and why do we make changes? It is not unusual, in fact, more common than not, that the parties will agree to make some change in the contract. Well, then obviously these changes, modifications, you hear it called a lot, that has to also be agreed upon in writing. But here's where you want to be really careful about making changes. There's a big difference in making a modification to an offer and making a modification to a ratified contract. So what are we talking about here? If I make an offer to the seller and he counters back, because maybe what I offered wasn't enough for the seller, so they're counter back wanting more money, then typically they'll just, if I put $300,000 as my offer, and the seller says, no, I got to have $320,000. Typically, they'll just draw a line through the $300,000, in the offer. They'll just draw a line through it, and then write in or type in $320,000. So whatever amount the seller wants to counter. They must initial that change, or that modification must be initialed and dated. Initial and date. Y'all remember that. All changes or modifications must be initialed and dated by all parties. So when they send that counteroffer back to the buyer, then obviously they can look back through their offer and see, has the seller made any changes or modifications to the offer. And obviously, they see in this case, they see where he changed the sales price from $300 to $320. Well, if the buyer's okay with that, they're willing to pay the additional amount of money, then the buyer would initial and date that change, and then that signifies acceptance by both parties, because now that change or modification has now been initialed and dated by all parties. Has to be there. If anybody involved in the transaction did not initial and date whatever change was made, then that renders the contract invalid, okay? Because you've got to have initial and dates by all parties. So, that's what you need to understand on the offer part. Now, once the contract is accepted, in other words, the buyer and the seller both have agreed to the terms, they've all signed, they've initialed and dated wherever they needed to, now the contract is considered ratified. Once the contract is ratified, means it's been accepted by all parties, you cannot go back in and start making changes to the contract. You cannot do that. I'm telling you, there are agents that do it, and when you do that, you're potentially rendering the entire contract invalid now. You cannot modify a ratified contract. So does that mean that we cannot agree to additional changes after the contract's been accepted? That's not what I'm saying. But what I am saying is this, if we do need to make a change or add an additional agreement or whatever, then that's what we have to use addendums for. That's a separate sheet of paper. You'll have to go get you another piece of paper, an addendum. Write up whatever it is you need written up. Now, I will tell you, hopefully, we already have pre-printed addendums, because a lot of times when we go to add stuff, they're very common things. So maybe an attorney has already drawn up an addendum with the verbiage you need for whatever it is you're trying to accomplish. But anyway, you get the addendum signed by both parties, and then you attach the addendum to the contract. Okay? So you can make changes to the offer, to the contract, but as long as it has not been ratified or accepted yet. But once it's ratified, now you have to start adding agreements through an addendum. You write it up, attach the addendum to the contract, and then there you go. Okay? But just make sure that whether you're modifying the original offer or agreeing to addendums to be added to the contract, make sure you've got all parties signed and dated everywhere they need to sign and date. When I say all parties, you may have 4 owners of the property, 4 sellers. Well, can just one of the 4 sign, initial, date, and that be okay? No. All 4 sellers have to sign, initial, and date wherever they need to initial and date. And then same thing on the buyer side. So when we say all parties, we're not talking about just a party from each side. All parties on both sides must make sure they sign, initial, and date everywhere that needs to be signed. And then obviously, make sure everybody, in fact, does consent. Nobody's being pressured. No one is acting under duress to either buy or sell. That's just not right. And it's certainly not legal. Okay? So those are things you need to understand about contract law.